The member states agreed on a negotiating mandate to review the rules on the protection of privacy and confidentiality in the use of electronic communication services. These updated rules on electronic privacy will define the cases in which service providers are authorized to handle electronic communications data or to have access to data stored on end users' devices. That agreement allows the Portuguese presidency to start talks with the European Parliament on the final text. The existence of strong privacy rules is vital to create and maintain trust in a digital world. It was not easy to define the Council's position, but we now have a mandate that reflects a good balance between a solid protection of people's private lives and the promotion of the development of new technologies and innovation. The Portuguese presidency is very pleased to now start talks with the European Parliament on this fundamental proposal, said Pedro Nuno Santos, Portuguese Minister for Infrastructure and Housing, Chairman of the Board. It is necessary to update the Electronic Privacy Directive, which is in force since 2002, in order to take into account new technological and market developments, such as the current widespread use of voice over IP and web-based messaging and email services, as well as such as the emergence of new techniques to track online user behavior. The draft regulation on electronic privacy will repeal the directive currently in force. As a lex specialis in relation to the General Data Protection Regulation, the GDPR, it will complement the GDPR and introduce specifications on the matter dealt with therein. For example, contrary to the provisions of the GDPR, many of the provisions on electronic privacy will apply to both natural and legal persons. Within the scope of the Council's mandate, the regulation will apply to the content of electronic communications transmitted through publicly accessible services and networks, as well as to metadata related to communication. Metadata encompasses, for example, information about the location, the time, and the recipient of the communication, being considered potentially as sensitive as the content. In order to ensure full protection of privacy rights and to promote a reliable and secure Internet of Things, the rules will also be extended to machine-to-machine data transmitted over a public network. The rules will apply when end users are in the EU, also covering cases where processing takes place outside the EU or where the service provider is established or located outside the EU. As a rule, electronic communications data will be confidential. Any interference, including listening, monitoring, and processing of data by someone other than the end user, will be prohibited unless the regulation on privacy and electronic communications allows it. Authorized processing of electronic communications data without user content includes, for example, ensuring the integrity of communication services, checking for the presence of malicious programs or viruses, or even cases where the service provider is bound by law of the EU or one of the member states in terms of prosecuting criminal offenses or preventing threats to public security. Metadata can be treated in particular for billing purposes or to detect or prevent fraudulent uses. With the user's consent, service providers may in particular use metadata to present traffic movements in order to help public authorities and transport operators to develop new infrastructures where they are most needed. Metadata can also be treated to protect vital user interests, in particular to monitor epidemics and their spread, or in humanitarian emergencies, in particular natural or man-made disasters. In certain cases, providers of electronic communications networks and services may process metadata for purposes other than those for which they were collected, even if this does not imply user consent or is based on certain provisions regarding legislative measures adopted under the EU or member state law. This treatment for other purposes must be compatible with the initial purpose, applying specific safeguards. Since the user's terminal equipment, including hardware and software, can store highly personal information, such as photographs and contact lists, the use of processing and storage capabilities and the collection of information contained in the device will only be permitted with the user consent or for other specific and transparent purposes set out in the regulation. The end user must be able to choose whether or not to accept connection testimonies or similar identifiers. Access to a website subject to the consent to use connection testimonials for other purposes as an alternative to a paid access system will be allowed if the user can choose between that offer and an equivalent offer from the same provider that does not imply his consent to regarding the use of connection testimonies. In order to avoid the so-called fatigue of consent to the use of connection testimonials, the end user will have the possibility to consent to the use of certain types of connection testimonials, establishing in the presets of his navigation program permissions for one or more providers. Software providers will be encouraged to make it easier for users to create and change permissions on their browser programs and withdraw their consent at any time. The text also includes rules on online identification, public lists, unsolicited communications, and direct marketing. The regulation will enter into force 20 days after its publication in the official journal of the EU and will start to apply 2 years later. The mandate defined was approved by the ambassadors, the meeting in the Committee of Permanent Representatives of the Council. And the Commission presented its proposal in January 2017 already. The Council and the European Parliament will negotiate the terms of the final text now. And if you want to stay informed, please subscribe to my channel and to my other channels. I'll see you in my next video. Auf Wiedersehen.